Case 1. Cora Weberg, Multi-Care Good Samaritan Hospital, Puyallup, Washington. Pierce County 12 patients walked into an emergency room in Puyallup, Washington, received medical care from a registered nurse, and left carrying a disease they did not arrive with. That is where this case begins, not with a single incident, not with one mistake, but with a pattern of conduct that stretched across 7 months inside one of the most trusted institutions in Pierce County. The case of Cora Weberg is the most thoroughly documented nurse criminal prosecution in Washington state history, and it begins not in a courtroom, but in a hospital's own data systems. Cora Weberg was a registered nurse assigned to the emergency department at Multi-Care Good Samaritan Hospital in Puyallup, Washington. She held a valid nursing license, had passed her credentialing requirements, and was considered a functioning member of the clinical team. Between August 4, 2017 and March 23, 2018, Weberg was present for ER shifts at that hospital, and during that same window, something was going wrong with the medication dispensing system that no one had yet identified. The first indication that something had gone wrong came in December of 2017, when 2 patients with no prior history of hepatitis C tested positive for the virus. Both results came back with a genetically identical strain. In the field of epidemiology, that kind of match is not a coincidence. It is a signal. The Tacoma-Pierce County Health Department was notified. The Washington Department of Health became involved, and within weeks, a formal investigation was underway that would eventually bring in the Centers for Disease Control and Prevention's Epidemic Intelligence Service. The investigation that followed was methodical, structured, and forensically precise. Investigators began by identifying every patient who had been treated in the emergency department during the period in question. That number came to roughly 2,985 patients in total. Of those, Multi-Care sent written notification to 2,762 patients who had been treated in the ER while Weberg was working. Out of that broader pool, Weberg had personally treated 208 patients. Ultimately, 1,863 patients were tested. The final confirmed count of newly infected patients stood at 12 individuals, all carrying genetically matched hepatitis C strains. A 13th patient had a pre-existing chronic infection that investigators identified as the likely original source of the viral strain. The forensic methodology in this case is significant and worth understanding in detail because it represents a modern standard for healthcare outbreak investigations. The CDC's Epidemic Intelligence Service deployed genetic sequencing technology to analyze the specific strain of hepatitis C found in each confirmed case. The results were unambiguous. Every newly infected patient carried a strain that was genetically identical to one another, while patients treated in the same ER by other nurses carried strains that were, in the CDC's language, genetically distant. There was one common thread connecting all 12 newly infected patients: Cora Weberg. Alongside the genetic sequencing work, investigators examined the hospital's automated drug dispensing system, a computerized platform that tracks every time a medication is accessed, by whom, at what time, and in what quantity. The audit logs from that system told a clear story. Weberg had accessed the system far more frequently than any other staff member in the emergency department. EIS Officer Henry Juvena stated the following in his published report. The nursing staff member was identified by reviewing the automated drug dispensing system's logs, which showed that the nurse had accessed the system more frequently than other staff members in the hospital's emergency department. When investigators interviewed Weberg directly, she provided a written admission. She acknowledged that she had diverted injectable fentanyl and hydromorphone from the hospital for her personal use. She described her method in writing. After a patient received an order for a medication, she would administer the ordered dose to the patient, then withdraw the remainder into a syringe to take home. She publicly stated that she had never shared a needle with any patient. Investigators, however, were focused less on mechanism and more on epidemiological outcome. And the outcome was documented: 12 patients infected. In early May of 2018, Weberg was arrested at the United States-Canada border on suspicion of 2 counts of second-degree assault. The Pierce County prosecuting attorney ultimately did not file those state-level charges. The case moved into federal jurisdiction instead. Weberg's nursing license was suspended by the Washington State Department of Health in May of 2018, and she subsequently lost or surrendered nursing licenses in multiple states. For 5 years, the case moved through the legal system without a criminal conviction. That changed in September of 2023. Weiberg appeared in the United States District Court for the Western District of Washington and entered a guilty plea to one federal count of tampering with consumer products. The maximum exposure under that charge at the time of her plea was 10 years in federal prison, 3 years of supervised release, and a fine of $250,000. The final sentence imposed by the court was not confirmed in publicly available reporting as of this documentary's research period, and viewers seeking the confirmed sentencing outcome are encouraged to consult the court's PACER filing system for the Western District of Washington. On the civil side, a class action lawsuit filed by patients on behalf of the affected individuals against MultiCare Health System made its way to the Washington Supreme Court, which in January of 2024 allowed the patient classes to proceed. The case was ultimately resolved through a proposed settlement in which MultiCare agreed to pay $4 million into a settlement fund. That settlement became final on January 19, 2026, with distributions to eligible class members expected in March of 2026. The policy impact of this case extends well beyond Pierce County. The CDC published the Weiberg outbreak as a national teaching case under the classification Hepatitis C virus transmission associated with drug diversion in a local hospital emergency department, Washington State, August 2017 through March 2018. The agency used the case to issue guidance urging hospitals across the country to, in their words, secure and actively monitor use of controlled substances at their facilities in order to protect their patients from harm caused by drug diversion. MultiCare itself revised its internal narcotic use reporting systems to create automated flags for any employee whose drug dispensing access patterns deviate from standard practice among their peer group. This case established several precedents that continue to shape how hospitals monitor controlled substance access in Washington state and nationally. The combination of genetic sequencing technology and automated dispensing audit logs proved to be a replicable investigative model, one that has since been cited in other healthcare setting outbreak investigations. The Weiberg case remains the clearest documented example in Washington's recorded history of a licensed nurse whose pattern of drug diversion directly produced a public health outcome affecting dozens of patients and requiring the notification of nearly 3,000 individuals. The case raises questions that the healthcare industry continues to work through. How do automated monitoring systems identify diversion before an outbreak occurs rather than after? And what institutional structures should exist to close the gap between a nurse's first unauthorized access of the dispensing system and the point at which that access is investigated? The Weiberg prosecution represents the legal resolution of one specific case. The broader systemic questions it generated continue to be examined by healthcare regulators, hospital administrators, and public health agencies across the country. What this case confirmed above all else is that forensic epidemiology, the combination of genetic science and digital audit trail analysis, has fundamentally changed the way healthcare setting crimes can be detected, documented, and prosecuted. Case 2. David Mungai Njenga, Heritage Medical Staffing, Pro-Med Alliance, King County, Washington. When the patients at long-term care facilities across Washington state were being assigned nurses through a staffing agency, their families trusted that those nurses were licensed, credentialed, and qualified. What investigators eventually uncovered was that some of those workers could not perform basic clinical tasks, and that the entire operation was built on stolen identities. This is the case of David Mungai Njenga, and it is one of the most structurally complex healthcare fraud prosecutions in Washington state history. David Mungai Njenga was a resident of Kent, Washington. He was not a licensed nurse, not a credentialed healthcare worker, and not affiliated with any medical institution in an official capacity. What he was, according to court records and the findings of the Washington Attorney General's Medicaid Fraud and Abuse Division, was the operator of 2 fraudulent nurse staffing agencies, Heritage Medical Staffing Incorporated and its successor entity, Pro-Med Alliance Medical Staffing Incorporated. Between May of 2017 and October of 2019, those 2 companies operated as functioning businesses in the Washington healthcare staffing market, placing workers at long-term care and nursing facilities in Bothell, North Bend, Redmond, Shoreline, Vashon Island, and Yakima, among other locations. The mechanism of the fraud was identity theft at a professional level. Njenga obtained the names, license numbers, and professional credentials of 5 licensed Washington-registered nurses, individuals who had completed their nursing education, passed their board examinations, and held valid state-issued licenses. He then used those stolen identities to create fraudulent employment records and place entirely different, unqualified workers at healthcare facilities under the names and credentials of those 5 real nurses. The facilities believed they were receiving licensed, qualified clinical staff. What they were actually receiving, in multiple documented instances, were workers who could not perform fundamental nursing tasks. The national nursing press reported on this case with particular concern because of what investigating agencies found when they examined the conduct of these imposter workers on the floor. In one documented instance, an imposter nurse was unable to take a patient's blood pressure, a skill typically introduced in the first weeks of any nursing education program. In other instances, incorrect medications were dispensed to patients. The imposter workers were also being paid substantially less than what a licensed registered nurse would earn, meaning that Njenga's agencies were billing facilities at licensed nurse rates, paying workers far below that level, and retaining the difference. The investigation was conducted by the Washington Attorney General's Medicaid Fraud Control Division, also known as the Medicaid Fraud and Abuse Division. The specific investigative methods and timeline of the inquiry are not detailed in available public documentation, but the scope of the resulting prosecution, 11 criminal counts, reflects the breadth of the conduct the investigation uncovered. The 5 real nurses whose identities were stolen were directly harmed through professional credential theft, and the patients at the receiving facilities were placed at documented clinical risk through their exposure to unqualified workers. In May of 2026, the case came to its conclusion in King County Superior Court. A jury convicted Njenga on all 11 counts following a full trial. The counts were as follows: 1 count of leading organized crime, classified as a Class A felony under Washington law. 5 counts of first-degree identity theft, 1 count of second-degree identity theft, 3 counts of first-degree theft, and 1 count of second-degree theft. Washington Attorney General Nick Brown issued a statement following the verdict that read, "In part, we are gratified to get justice for the many people harmed and put at risk by these crimes." The sentencing hearing was scheduled for June 16, 2026 in King County Superior Court. At that time, Njenga faced a recommended sentencing range of approximately 12 to 16.5 years in state prison, along with up to $50,000 in criminal penalties. The state of Washington had also already obtained default civil judgments totaling $40,500 against each of his 2 business entities. Viewers seeking the confirmed sentencing outcome from the June 16, 2026 hearing are encouraged to consult King County Superior Court's public filing records. The Njenga case emerged nationally as an example of a specific and growing vulnerability in the healthcare staffing industry: the relative ease with which professional license numbers can be obtained and misused in a market where staffing shortages create pressure on facilities to fill shifts quickly, and where credential verification systems are not uniformly robust. National nursing publications, including nurse.org, covered the verdict and used it to highlight the issue of imposter nurses and stolen credentials as a category of healthcare fraud that multiple states were beginning to track more systematically. The legal framework used to prosecute this case is also significant. The leading organized crime charge, a Class A felony, reflects Washington prosecutors' determination that Njenga's operation was not an isolated incident of fraud, but a structured, ongoing criminal enterprise with multiple participants, sustained over more than 2 years, targeting vulnerable populations and exploiting licensed professionals. That charge carries the most serious sentencing consequences under Washington law, and signals the state's view of how seriously this category of healthcare fraud should be treated. For the long-term care facilities involved, this case posed immediate operational questions about their own intake and credential verification practices. A facility receiving a worker from a staffing agency operates on the assumption that the agency has verified that worker's licensure against state records. The Njenga case demonstrated that this assumption, without independent verification steps at the facility level, creates a gap through which unqualified workers can be placed directly into patient care roles. Washington's Department of Health and the Department of Social and Health Services have each engaged with the credential verification question in the years since this case came to light. The patients who received care from imposter nurses placed by Nyanjaga's agencies were largely elderly or disabled long-term care residents, individuals whose clinical complexity and vulnerability made the presence of unqualified caregivers particularly consequential. The full extent of patient harm in this case was not specified in available court records, but the nature of the imposter conduct, incorrect medications dispensed, inability to perform basic assessments, reflects a category of risk that long-term care regulators take seriously. This case is, at its core, a fraud prosecution. But the underlying harm it documents, patients receiving care from unqualified workers presenting false credentials, is a patient safety issue with direct clinical implications. That intersection between financial crime and clinical risk is what makes the Njenga case both a legal precedent and a regulatory warning. Case 3, Jolene Larson, Mary Haven Care Center, Snohomish, Washington, Western District of Washington. The patients at the center of this case were already among the most medically vulnerable people in the state of Washington. They were hospice patients, individuals in the final stage of terminal illness, for whom the management of pain is not a comfort measure, but a clinical necessity. The medications prescribed to them were specifically calibrated to address that need. And for a period of 6 months, those medications were being systematically removed and replaced with tap water. This is the case of Jolene Larson. Jolene Larson was 38 years old at the time of her arrest. She was a licensed practical nurse who had worked at Mary Haven Care Center in Snohomish, Washington for 14 years. Her tenure at the facility was long enough that she had become a familiar and trusted figure in the clinical environment, a staff member whose access to the medication room and the facility's pharmaceutical supplies was routine and unremarkable. That familiarity, investigators would later conclude, was part of what made the diversion possible for as long as it continued. Between November of 2009 and May of 2010, a period of approximately 6 months, Larson removed morphine sulfate from prescription vials belonging to patients at Mary Haven. She did not simply take the medication and leave. She replaced the morphine with tap water, resealing the vials in a way that made them appear intact and full. The substituted vials were then returned to the medication storage area, where they remained available to be dispensed to patients during subsequent shifts that Larson may or may not have been working herself. The discovery of the diversion came not from a monitoring system or an administrative audit, but from clinical observation. A nurse working at the facility noticed that a vial of morphine sulfate appeared lighter in color than the standard preparation. The visual change was enough to trigger concern. Rather than using that vial for a patient, the nurse set it aside and used a different supply. That decision, to act on a clinical observation rather than proceed as normal, was the pivot point that initiated the investigation. The subsequent investigation brought in 3 federal and law enforcement agencies: the Drug Enforcement Administration, the FDA Office of Criminal Investigations, and the Snohomish Police Department. The collaboration between these 3 agencies reflects the multi-jurisdictional nature of pharmaceutical diversion cases, which involve both federal controlled substances law and state criminal statutes. The DEA's involvement was particularly significant given that morphine sulfate is a Schedule II controlled substance under federal law. Laboratory analysis of the tampered vials confirmed the substitution. The contents were not morphine sulfate but water. The investigation also documented at least one instance in which a diluted vial had already been used. The compromised medication was administered to a patient, and the patient's pain was not adequately addressed until additional pain medication was provided through a separate supply. This instance was central to the charges because it moved the case from simple drug theft into the territory of direct patient harm through the delivery of a non-therapeutic substitute. Larson was charged under federal law with tampering with consumer products, the same charge used in the Weiberg and Allen cases, and one of the primary federal tools available for prosecuting pharmaceutical tampering in healthcare settings. She entered a guilty plea on November 11, 2010, in United States District Court in Seattle. The sentencing hearing took place in March of 2011 before United States District Judge James L. Robart. Judge Robart sentenced Larson to 1 year in federal prison and 3 years of supervised release. In his remarks from the bench, Judge Robart addressed directly the nature of what Larson had taken and from whom she had taken it. He noted that the medications she diverted had been prescribed specifically to make dying patients' final days as free of discomfort as possible, and that her actions had the documented capacity to increase the suffering of the most medically vulnerable patients in the facility's care. The DEA's press release following the sentencing, dated March 7, 2011, described the case in terms that emphasized the federal government's view of pharmaceutical diversion in hospice settings as a particularly serious category of misconduct. The agency's messaging underscored that the theft of controlled substances from patients in end-of-life care carried consequences that extended beyond the individual nurse's criminal conduct and into the clinical outcomes experienced by patients who depended on those medications. The Larson case is representative of a category of pharmaceutical diversion that occurs in long-term care and hospice settings with a frequency that public health agencies have consistently flagged as underreported. The combination of staffing familiarity, access to controlled substances, and the clinical vulnerability of the patient population creates conditions that increase both the opportunity and the potential impact of diversion. Federal and state agencies have used cases like Larson's to advocate for more frequent and randomized audits of controlled substance vials in long-term care settings, including visual inspection protocols for morphine preparations that can detect the kind of color change that led to the discovery in this case. The Larson prosecution also illustrates the importance of clinical observation as a discovery mechanism. Automated drug dispensing systems, which were central to the Weiberg investigation, were not yet universally deployed in long-term care settings in 2010. In their absence, the attentiveness of a single nurse, noting an unexpected visual characteristic of a medication vial, served as the primary detection mechanism. That observation, acted upon immediately and reported through the appropriate channels, ultimately triggered a multi-agency federal investigation and resulted in a federal conviction. For the 14 patients whose records were reviewed during the investigation, and the at least one patient directly documented as having received a tampered vial, the Larson case represents a direct breach of the clinical duty of care that defines the nursing profession. The facility, Mary Haven Care Center, cooperated with investigators throughout the inquiry. No facility-level charges were filed. Case 4. Rocky Allen, Northwest Hospital, Seattle/Naval Hospital Bremerton/Lakewood Surgery Center, Washington State. This case involves a traveling surgical technologist whose conduct in multiple states triggered federal criminal prosecution, the notification of more than 1,400 Washington patients, and a sentencing that ultimately exceeded 7 years in federal prison. The case of Rocky Allen begins in Washington State, extends to Colorado, and ends in a federal courtroom. And it raises questions about how traveling healthcare workers move between states and facilities without their prior disciplinary histories following them. Rocky Allen was a traveling surgical technologist and former Navy corpsman who had served in the United States military, including a deployment to Afghanistan. His role in surgical settings was not that of a licensed nurse, but of a credentialed technologist, meaning he worked in operating rooms and surgical suites, with access to the controlled substances used in those environments, including the injectable opioid fentanyl. His work history in Washington State included 3 facilities: Northwest Hospital and Medical Center in Seattle, where he worked from January through March of 2012, Naval Hospital Bremerton, where he worked from 2008 through 2011, and Lakewood Surgery Center, where he worked briefly in late 2011. The pattern of conduct investigators documented was consistent across multiple facilities and multiple states. Allen would divert fentanyl from surgical supply, replacing the fentanyl-loaded syringes with syringes containing saline solution. Those saline-substituted syringes would then enter the surgical workflow, where they could be administered to patients under the assumption that they contained the intended medication. The clinical risk from this substitution was direct. Patients in surgical settings who received saline instead of fentanyl would not receive the pain management or anesthetic effect the medication was intended to provide. Allen is HIV positive, specifically subtype B, with negative test results for hepatitis B and hepatitis C. That medical fact became central to the public health response in Washington State once his conduct became known, because every patient who had undergone surgery at a facility where Allen had worked was potentially exposed through the syringe swap mechanism. The Washington State Department of Health notified Northwest Hospital that as a result of Allen's employment there, patients who had surgery between December 30th, 2011 and March 9th, 2012, a period of approximately 10 weeks, should be informed and offered testing. That notification reached more than 1,300 patients. Lakewood Surgery Center sent similar notifications to approximately 135 patients. The criminal case that ultimately resulted in Allen's prosecution and conviction occurred not in Washington but in Colorado. At Swedish Medical Center in Englewood, Colorado, Allen was employed as a traveling surgical technologist beginning in August of 2015. On January 22, 2016, a neurospine coordinator at Swedish Medical Center witnessed Allen swap a syringe. The coordinator observed Allen remove a fentanyl-loaded syringe from the surgical supply and replace it with a syringe containing saline. The coordinator took possession of the syringe Allen had set aside and immediately alerted the anesthesiologist. A federal investigation was initiated. Allen's urine was tested and returned positive results for fentanyl, norfentanyl, and marijuana. Allen was charged in United States District Court for the District of Colorado. In July of 2016, he entered a guilty plea to 2 federal counts, tampering with a consumer product and obtaining a controlled substance by deception. His sentencing was conducted before United States District Judge Raymond P. Moore in November of 2016. Judge Moore imposed a sentence of 78 months in federal prison, equivalent to 6.5 years, along with 3 years of supervised release. That sentence was subsequently extended by an additional 12 months after Allen was found to have violated a court order. Before reporting to federal prison as required, Allen traveled to Idaho, a violation of the terms set by the court in the period between his guilty plea and his self-surrender date. He was held in criminal contempt of court as a result, and Judge Moore added 1 year to his total sentence. The 10th Circuit Court of Appeals later reviewed the original 78-month sentence and upheld it as procedurally and substantively reasonable. In the background of this case is a prior military disciplinary proceeding that is relevant to understanding the pattern. While Allen was deployed with the United States Navy in Afghanistan in 2011, he was court-martialed for stealing fentanyl from military medical supplies. He received a general discharge from the Navy as a result of that proceeding. That prior court-martial occurred before he began his Washington state assignments and before the Colorado conduct. Yet his access to controlled substances in civilian surgical settings continued. Washington State responded to the public disclosure by suspending Allen's surgical technologist credential on February 29, 2012, after learning of the allegations that had emerged in connection with the Colorado investigation. The suspension prevented any reactivation of his credential in Washington until his legal matters were fully resolved. Investigators and regulators have used this case to advocate for centralized, multi-state credential monitoring systems for healthcare workers, a policy gap that cases involving traveling workers in multiple states make particularly visible. In Colorado, Swedish Medical Center notified approximately 3,000 patients who had surgery between August 17, 2015 and January 22, 2016 that they should consider seeking testing. Reports at the time indicated that approximately 2,500 of those patients took advantage of the offered testing. No patients across any of the affected facilities in Washington or Colorado were reported to have contracted HIV or other bloodborne infections as a result of documented contact with Allen during his employment periods. The Allen case is significant in the context of this documentary for 3 reasons. First, it demonstrates that the harm flowing from pharmaceutical diversion in surgical settings extends beyond the individual nurse or technologist's drug use and into the direct clinical environment of the patient, through substituted syringes that affect anesthetic management. Second, it illustrates how a prior disciplinary record, in this case, a military court-martial for the identical conduct, did not prevent subsequent civilian healthcare employment. Third, it shows how the combination of an alert coworker observation, federal law enforcement response, and forensic toxicology testing can resolve a case within weeks of the triggering incident. Case 5. Larry Lee, Spanaway, Washington, Pierce County. This case involves a caregiver who was not a licensed nurse at the time the events in question occurred, but whose background in licensed home care and whose continued receipt of payment for care services places it within the documented record of caregiver criminal conduct in Washington state. The victim in this case was a 59-year-old man named George Philip Carter, an individual with autism who had lived in the defendant's home for several years and who depended entirely on the defendant for his daily care and medical needs. Larry Lee was 51 years old and a resident of Spanaway, Washington. His background in licensed home care was established. His former spouse had been a licensed nurse, and the two of them had previously operated a licensed home care business together. After that relationship ended, and his former spouse departed, Lee did not take the steps required by Washington law to obtain a new individual caregiver license. He did not transfer the existing license into his name alone or apply for a new one through the appropriate regulatory channels. He continued, however, to provide care to George Philip Carter and to receive $850 per month for those services. The legal framework that applies to this situation in Washington state is clear. Individuals providing paid care to vulnerable adults are required to hold appropriate licensure and to maintain that licensure in compliance with state regulations. Lee was operating outside those requirements from the point at which the prior license lapsed following his former spouse's departure. The care arrangement continued regardless, and over time, the condition of George Philip Carter deteriorated in ways that required medical attention. The central factual finding in this case, as argued by the prosecution before a Pierce County jury, was not that Lee took an action that harmed Carter, but that he failed to take an action that could have preserved Carter's life. Specifically, the evidence presented at trial established that Carter's medical condition had reached a point at which he required professional medical evaluation and intervention, and that Lee did not obtain that care. Carter died. The cause of death was determined to be the result of severe medical neglect. Pierce County Deputy Prosecutor Erica Nohavik presented the case to the jury on the theory of second-degree murder by omission, a legal theory that holds a defendant criminally responsible for a victim's death when the defendant had a legal duty of care toward the victim, was aware of the victim's need for assistance, and deliberately or recklessly failed to provide or obtain that assistance. Carter, as a nonverbal adult with autism who lived in Lee's home and depended on him entirely, was legally recognized as an individual to whom Lee owed that duty of care. The jury agreed. In June of 2016, the Pierce County jury returned a verdict of guilty on the charge of second-degree murder. The verdict reflected the jury's finding that Lee's failure to act constituted the legal equivalent of a criminally culpable act under the circumstances of Carter's total dependence on him. The sentencing hearing was conducted before Pierce County Superior Court Judge Michael Schwartz on June 30, 2016. Judge Schwartz sentenced Lee to 18 years in state prison. In his remarks from the bench, Judge Schwartz addressed Lee directly, stating that Carter could not dial the phone, referring to Carter's inability, as a nonverbal individual with autism, to call for help or seek medical attention on his own behalf, and that Lee could have made that call and did not, and that this failure ultimately resulted in Carter's death. Carter's sister appeared at the sentencing hearing and asked the court for leniency on Lee's behalf. That request was noted in the record. Judge Schwartz nonetheless imposed the 18-year term, reflecting the court's assessment of the severity of the neglect and the duration over which Carter had been dependent on Lee without receiving the medical attention his condition required. The case carries a set of regulatory implications that Washington state agencies have continued to examine. The gap between the lapse of a caregiver's license and the point at which a dependent care recipient is harmed is precisely the kind of monitoring failure that the Department of Social and Health Services licensing and oversight systems are designed to prevent. In the Lee case, there was no documented mechanism that identified, prior to Carter's death, that an unlicensed caregiver was receiving payment for services to a vulnerable adult. The existing oversight structures did not generate an alert or a follow-up visit that would have surfaced the licensing gap. The Seattle Times investigative series on Washington's adult family home industry, which ran parallel to cases like this one, documented a pattern in which the state's oversight resources were insufficient to maintain regular monitoring contact with the volume of licensed and unlicensed care arrangements operating across Washington's counties. The Lee case is one data point within that broader documented pattern. For the purposes of this documentary, the Lee case represents a category of caregiver criminal conduct that is distinct from the drug diversion and pharmaceutical tampering cases covered elsewhere in this episode. The harm here was not an act performed against the victim, but a sustained failure to act, and the legal system's response was to treat that failure in the context of total dependent care as criminal homicide. Case 6. Antonia Mala and Milagros Mendoza, TLC Adult Family Home, Washington State. This case involves two individuals associated with a licensed adult family home in Washington State, a resident who sustained injuries following a facility incident, and a subsequent prosecution that resulted in what legal observers described at the time as a first in Washington State history. It is a case about the duty of care owed to vulnerable adults in residential care settings, and about the legal obligations that govern how facilities must report incidents involving those adults. Adult family homes in Washington State are a specific category of licensed residential care facility. They are smaller than nursing homes, typically operating in a converted residential structure, and they serve adults who need assistance with daily living activities or who have medical needs that require consistent support. Washington's Department of Social and Health Services licenses and oversees these facilities. Among the legal obligations that come with that license is a requirement to notify DSHs promptly when a resident is injured or when an incident of abuse or neglect occurs within the facility. In March of 2007, an oxygen pump at the TLC Adult Family Home exploded. The explosion resulted in burns to a resident named Audrey Hopkins, who was 68 years old. The immediate question that arose in the aftermath of the incident was whether the facility had fulfilled its legal obligations, specifically, whether it had notified DSHs as required by state law in a timely manner following the incident involving Hopkins. Investigators determined that Antonia Mala, the owner of TLC Adult Family Home, had failed to provide the required immediate notification to DSHs. That failure to report, not the explosion itself, and not the burns sustained by Hopkins, became the basis for criminal prosecution. Mala was charged accordingly. Milagros Mendoza, a caregiver employed at TLC Adult Family Home, was charged separately with reckless endangerment. Her case proceeded first. In 2009, Mendoza was convicted of reckless endangerment and sentenced to 30 days in jail. Mala's case was handled by King County Senior Deputy Prosecutor Paige Ulray, a prosecutor with extensive experience in cases involving elder abuse and the rights of vulnerable adults. Mala ultimately entered a guilty plea to the charge of failure to report neglect. The sentence she received was probation and 240 hours of community service. The significance of Mala's prosecution, as noted by legal observers and reported by the Seattle Times in its Seniors for Sale investigative series, was that it represented the first time in Washington state history that a criminal conviction had been obtained against an adult family homeowner specifically for the failure to report neglect to state authorities. Prior to this case, the reporting obligation existed in statute but had not been enforced through criminal prosecution in this manner. That prosecutorial precedent matters because the reporting requirement is one of the primary mechanisms through which the state is supposed to learn about adverse events in adult family home settings. If facilities can fail to report without criminal consequence, the oversight system loses one of its core inputs. The Mala prosecution established that the reporting obligation carries real legal weight and that violations of that obligation can and will be prosecuted. The Seattle Times investigation that provides context for this case documented a pattern of concealment that extended well beyond TLC. Reporters found that over the 5 years preceding their investigation, at least 357 adult family homes in Washington state had concealed cases of abuse or neglect involving their residents, and that many of those cases involved serious injury or death. The investigation identified structural features of Washington's adult family home system that created conditions favorable to concealment: limited inspection frequency, understaffed regulatory oversight, and a financial model that created incentives for facilities to avoid the scrutiny that comes with mandatory reporting. The Mala case, small as its sentence was relative to other cases in this documentary, occupies a specific and documented place in Washington state's legal and regulatory history. It is the case that demonstrated criminal accountability for reporting failures, and in doing so, signaled to the hundreds of other licensed adult family homes in the state that the duty to report is not merely procedural, but legally enforceable. Audrey Hopkins, the resident at the center of this case, was 68 years old. The The documentary record does not specify the ultimate outcome of the injuries she sustained in the March 2007 incident, beyond their immediate nature as burns resulting from the oxygen pump explosion. Case 7. Arlie Leno, Narrows View Manor and related facilities, Pierce County area, Washington State. This case does not involve a single incident or a discrete criminal act prosecuted in a single proceeding. It is, instead, a documented record spanning 10 years of regulatory violations, accumulated evidence of resident harm, and ultimately the administrative revocation of an operator's license by the Washington State Department of Social and Health Services. The case of Arlie Leno represents one of the most extensively documented patterns of long-term care misconduct in Washington's adult family home and boarding home regulatory history. Arlie Leno operated a boarding home in the Tacoma Narrows area of Pierce County, Washington. The facility he operated served adults who, by definition of the boarding home category, required some level of residential support and care. Between 1990 and 2000, state inspectors from the Department of Social and Health Services conducted inspections and reviews of Leno's facility and its operation. Over the course of that 10-year period, those inspectors documented 135 separate violations, many of them classified as serious, and many accompanied by findings that residents had suffered actual harm. The pattern documented across those 135 violations reflects a facility in which basic standards of residential care were consistently not met. Inspectors found that Leno failed to create care plans for residents, individualized written documents that are legally required in Washington's licensed care facilities and that specify each resident's medical needs, daily care requirements, and the specific interventions staff are expected to provide. Without care plans, there is no documented standard against which to measure whether a resident's needs are being met or whether their condition is changing in ways that require attention. Among the specific incidents documented in the inspection record, one is noted with particular clarity in available sources. A resident fell and sustained a broken leg. Rather than arrange for the resident to be taken to a hospital, which is the standard response to a suspected fracture in any residential care setting, Leno's response was summarized in inspection documentation with the phrase, "We don't do that here." The resident was not taken to a hospital following the fall. Family members were not notified for nearly 3 hours after the incident occurred. That specific incident captures the character of the documented pattern. A facility where standard medical response protocols were not followed, where family notification requirements were not met, and where the operator's approach to resident medical needs did not align with the legal and clinical standards applicable to licensed facilities. Leno also employed a caregiver at the facility who had previously been convicted of felony assault. Washington state law specifically bars individuals with felony assault convictions from working unsupervised with vulnerable adults in licensed care settings. The presence of that employee, alone with residents, represented a direct regulatory violation and a documented safety concern that was identified during the inspection process. DSHS revoked Leno's boarding home license in 2000. The revocation followed the accumulated weight of the 135 violations and the inspection findings of actual resident harm. The revocation proceedings and the records supporting them are documented in the agency's administrative files. What makes the Leno case significant in the context of this documentary, and distinct from the criminal prosecutions covered in the other cases, is that it represents the regulatory enforcement track rather than the criminal prosecution track. The Washington state legal system has two primary mechanisms for addressing misconduct in licensed care settings: criminal prosecution through the courts and administrative action through DSHs. In the Leno case, the harm to residents was addressed through the administrative mechanism, license revocation, rather than criminal charges. This distinction matters because the regulatory record available through DCS is not always accessible to the public in the way that criminal court records are, and because the consequences of administrative action, revocation of a license, do not include incarceration and do not appear in criminal background check systems in the same way that criminal convictions do. The documented 135 violations and the findings of actual resident harm in the Leno case therefore exist in a regulatory record that has less public visibility than a criminal conviction would carry. The Seattle Times Seniors for Sale investigation used the Leno case and others like it to document what reporters described as a systemic pattern in which Washington's adult family home and boarding home industries were able to operate below adequate oversight standards for extended periods. The investigation's finding that 357 facilities had concealed abuse or neglect over a 5-year period gave context to individual cases like Leno's, not as anomalies but as part of a documented pattern with structural causes. For Washington state's regulatory agencies, the Leno case represents the kind of extended documentation, 10 years, 135 violations, that should, in an adequately resourced oversight system, generate more rapid administrative response. The eventual license revocation resolved the immediate operational question, the question of what adequate early warning mechanisms would have looked like, and whether the residents who suffered actual harm during that 10-year period received appropriate redress, remains part of the broader policy discussion that the Seniors for Sale investigation helped put before the Washington State Legislature. Case 8. Brian David Maruhashi, King County, Washington State. This case involves a licensed registered nurse in King County, Washington, who was criminally convicted on multiple assault charges and subsequently faced professional disciplinary action through the Washington State Nursing Commission. The case of Brian David Maruhashi is documented in 2 separate but related proceedings: the criminal prosecution in King County Superior Court and the professional disciplinary record maintained by the Washington State Department of Health's Nursing Commission. Brian David Maruhashi held a valid Washington State registered nurse license at the time the events in question came to the attention of law enforcement and regulatory authorities. The specific circumstances of the assaults that formed the basis of the King County Superior Court prosecution are not described in available public documentation beyond the charge classification: 4 counts of assault. The Department of Health disciplinary record, which was initiated in May of 2022, references the criminal convictions as the basis for the unprofessional conduct charges filed against his nursing license. The 4-count assault conviction in King County Superior Court established the criminal record that then became the trigger for the Nursing Commission's action. Washington State's nursing regulatory framework requires the Nursing Commission to investigate any licensed nurse who has been convicted of a crime that relates to the practice of nursing or that reflects on the licensee's fitness to practice. A conviction on 4 counts of assault falls within that category. The Nursing Commission's charge of unprofessional conduct, filed in May of 2022, reflects the formal regulatory response to the underlying criminal convictions. Under Washington law, a finding of unprofessional conduct can result in a range of sanctions, including probation with conditions, suspension of the nursing license, or permanent revocation. The specific outcome of the Nursing Commission proceedings, whether Maruhashi's license was suspended, revoked, or subject to conditions, is documented in the Department of Health's disciplinary records, which are publicly accessible through the agency's online license lookup system. The Maruhashi case is representative of a category of nursing misconduct cases that do not generate extensive public documentation during the investigative phase, but are nonetheless recorded through 2 parallel tracks: the criminal court system and the professional licensing system. The dual-track accountability structure, criminal prosecution through the courts, and professional disciplinary action through the Nursing Commission, is designed to address both the individual criminal conduct and the ongoing question of whether a convicted individual should continue to hold a professional license. For the patients who were the subjects of the 4 assault charges, the King County Superior Court verdict established the legal determination of wrongdoing. The Nursing Commission's subsequent action addressed the professional question of whether Maruhashi's continued licensure was consistent with the standards the Commission is charged with maintaining. Both proceedings are part of the documented record in this case. The limited narrative detail available in public sources for this case reflects the nature of Department of Health disciplinary records, which typically describe the charges and their outcome, rather than the specific facts underlying the criminal conduct. Investigators and journalists seeking the complete factual record of the underlying assault charges would need to access the King County Superior Court case files directly. What this case illustrates, in the context of this documentary's broader examination of nurse misconduct in Washington State, is the existence and function of the dual accountability mechanism that Washington law provides for: criminal prosecution for the specific conduct and professional disciplinary action for the question of licensure. The 2 proceedings operate independently, with different standards of proof and different potential consequences, but they are linked by the underlying facts and by the regulatory requirement that the Nursing Commission be notified of criminal convictions involving licensed nurses. Case 9. Johan Muntean. This case involves a registered nursing assistant who, with his spouse, owned and operated an adult family home in King County, Washington, and who was the subject of criminal proceedings and professional disciplinary action following allegations of sexual misconduct involving employees at the facility. The case of Johan Muntean is documented through King County District Court records and Washington State Department of Health Nursing Assistant Program disciplinary filings. Johan Muntean held a valid Washington State Registered Nursing Assistant credential and co-owned an adult family home with his wife. The facility was a licensed adult family home, subject to the oversight requirements administered by the Washington State Department of Social and Health Services and the Department of Health's Nursing Assistant Program. In that capacity, Muntean was both a care provider and a business operator in a setting that employed other caregivers to work with the facility's residents. The allegations that formed the basis of the criminal proceedings involve 3 employees at the adult family home. According to the charging documents and the terms of the subsequent court order, Muntean was alleged to have engaged in non-consensual physical contact with the 3 employees, including unwanted physical contact directed at them in the course of their work at the facility. The conduct alleged was classified as sexual misconduct and formed the basis for the action taken in King County District Court. In February of 2022, Muntean entered a stipulated order in King County District Court. The terms of that order required that he have no contact with the 3 employees who were named in the proceedings, that he enroll in a sexual deviancy and treatment program, and that he complete 20 hours of community service. The stipulated order resolved the criminal proceedings without a formal trial conviction, but established documented terms that reflected the court's assessment of the seriousness of the conduct alleged. Following the criminal court resolution, the Washington State Department of Health's Nursing Assistant Program filed a formal charge of unprofessional conduct against Muntean's nursing assistant credential in August of 2022. The professional disciplinary action followed the same pattern as the Maruhashi case covered earlier in this documentary. A criminal court proceeding produced a documented record that then triggered the professional regulatory response. Under Washington state law, the Nursing Assistant Program has authority to investigate and sanction nursing assistants whose conduct, including criminal conduct, reflects on their fitness to hold a credential and to work with vulnerable adults. The Muntean case is significant within the context of adult family home regulation in Washington because it involves misconduct by an owner-operator of a licensed facility, an individual who held both a professional credential and a business license that gave him authority over both residents and employees in the same setting. The combination of ownership, credentialing, and employment authority created a situation in which the 3 employees who were the subjects of the alleged misconduct were in a dependent position relative to Muntean in the workplace. Washington State's adult family home regulatory framework includes requirements that address the fitness of owners and operators, not just frontline caregivers. Cases involving owner-operator misconduct, as distinct from employee misconduct, present a specific regulatory challenge. The oversight mechanisms are primarily designed to monitor resident care quality, and conduct involving employees rather than residents requires coordination between employment law enforcement, criminal prosecution, and professional licensing action. The available documentation for this case is drawn from the Department of Health disciplinary records and the King County District Court record, both of which are publicly accessible. The underlying facts of the alleged conduct are described in the court's stipulated order and in the Nursing Assistant Program's charge filing. The outcome of the professional disciplinary proceedings, whether Muntean's credential was subject to suspension, revocation, or conditions, is accessible through the Department of Health's license lookup system. Case 10. Domanic Russell Shaver. This case involves a registered nursing assistant working in an in-home care setting in Spokane County, Washington, who was charged with theft from a client and with conduct in the workplace that formed the basis for professional disciplinary action. The case of Domanic Russell Shaver is documented through Spokane County Superior Court records and the Washington State Department of Health's Nursing Assistant Program disciplinary filings. Domanic Russell Shaver held a valid Washington State Registered Nursing Assistant credential and was employed as an in-home caregiver, a role in which he provided care directly to a client in that client's own residence. In-home care settings present a distinct oversight challenge compared to licensed facility-based care. The caregiver is typically alone with the client, without the peer supervision or administrative monitoring that exists in a nursing home or hospital setting. The client's vulnerability, which is by definition high, given the need for in-home care, combined with the absence of direct supervision, creates a setting in which misconduct can occur without immediate detection. The conduct alleged in the criminal case, filed against Shaver in Spokane County Superior Court in January of 2022, involved theft from the client's residence. Specifically, Shaver was alleged to have removed items from a safe belonging to the client and to have pawned those items. Theft from vulnerable adults by caregivers is a category of financial exploitation that Washington state law addresses, both through criminal statute and through the elder abuse provisions of the Adult Protective Services Act. Caregivers who steal from clients in their care are subject to criminal prosecution, and individuals convicted of financial exploitation of a vulnerable adult face specific statutory consequences under Washington law. In addition to the theft allegations, Shaver was alleged to have sent an explicit image to another caregiver who was also working in the client's home. That conduct, while not directed at the client, occurred within the care setting and was noted in the professional disciplinary documentation as a component of the unprofessional conduct charge filed by the Nursing Assistant Program. The Washington State Department of Health's Nursing Assistant Program filed a formal charge of unprofessional conduct against Shaver's credential in May of 2022, approximately 4 months after the Spokane County Superior Court criminal charge was filed. As in the Maruhashi and Muntean cases, the professional disciplinary action followed the criminal proceeding rather than running concurrently with it, reflecting the standard regulatory workflow in which the professional licensing body monitors criminal proceedings involving credential holders and initiates disciplinary action based on the outcome or the underlying factual record. The Shaver case is representative of a category of in-home caregiver misconduct that is particularly difficult to detect and prosecute. Unlike facility-based care settings, in-home care lacks institutional surveillance mechanisms. Discovery in this case presumably came through the client, a family member, or another caregiver observing the outcome of the theft, such as discovering that items were missing from the safe and reporting it to law enforcement. The involvement of a second caregiver in the same home, who received the explicit image, also suggests that the conduct came to light through that individual's cooperation with the investigation. Financial exploitation of vulnerable adults is one of the most commonly reported categories of elder and adult abuse in Washington state. The Department of Social and Health Services Adult Protective Services Program receives thousands of referrals annually, of which a significant proportion involve financial exploitation by family members, friends, or paid caregivers. Professional disciplinary action through the Nursing Assistant Program represents one layer of the response system, ensuring that credentialed caregivers who are found to have engaged in financial exploitation lose their professional credentials and are therefore barred from working as paid caregivers in regulated settings. The outcome of both the Spokane County Superior Court criminal case and the Department of Health Nursing Assistant Program disciplinary proceeding is accessible through the respective public record systems for both agencies. The full factual record, including the specific items alleged to have been taken, the value involved, and the final court disposition, is contained in the Spokane County Superior Court case file. The Shaver case, as the final case in this documentary, reflects the range of conduct that falls under the heading of nurse and caregiver misconduct in Washington state. From the multi-victim public health crisis documented in the Weberg case, to the large-scale fraud of the New Jenga operation, to the direct financial exploitation of a single vulnerable adult by a single caregiver in a home setting. Each case is different in scale, mechanism, and legal consequence. What they share is the common thread of a professional entrusted with the care of a vulnerable person and a documented failure of that trust.